Welcome, everybody, to In Conversation with Professor Edward Lee. This is Vibe Coding, AI Authorship, and the Future of Copyright. Obviously, thank you all so much for being here. I'm Mark Hogue, chair of the Beverly Hills Bar Association's AI in the Law section, along with my co-chair, Amanda Harris. And we are pretty delighted to introduce our speaker today, Professor Ed Lee. So, Ed is a legal scholar at Santa Clara University School of Law. His research focuses on the ways in which the internet, disruptive technologies, and globalization challenge existing legal paradigms. He teaches copyright law, design law, international IP law, and torts, and has co-authored case books in the latter three subjects. He founded, if his name sounds at all familiar, that's probably because you've discovered what he founded. ChatGPT is eatingtheworld.com, where he analyzes AI controversies, especially the copyright litigation and legal issues related to authorship, where he also has a superbly cool, literal, actual map of AI copyright lawsuits in the US right now, updated almost in real time. Relatedly, and admittedly somewhat self-servingly, I'm especially excited for today's conversation because, well, while my day job is running hoaglaw.ai and AI first practice advising SaaS and AI startups on IP and corporate matters, while my nights and weekends are completely consumed by vibe coding. I've shipped multiple websites and iOS apps just in the last 10 months. In fact, I just shared an open source contracts analysis app that runs locally on your computer. So full disclosure, I'm not exactly a neutral observer here. I have a deeply vested interest in how these questions play out. So I'll say it plainly. I think copyright law must evolve to recognize vibe-coded software, or we're going to find ourselves with an entire class of creative work that law sort of refuses to see. Anyway, with that bias on the table, Professor, thank you so much for being here. Amanda, take it away.
Awesome.
Thank you,
Thanks,
Mark.
Mark. And thank you so much, Ed, for joining us today. So I want to take a moment to set the table. So before we get to the doctrine, vibe coding ranges from a non-coder typing build me a flashcard app to a senior engineer iterating through dozens of prompts. So for folks who aren't copyright lawyers, can you explain what's actually lost when a program gets thin copyright versus thick copyright versus none at all? And if 92% or some, very high percentage of programmers are already using AI tools and about half of new code is AI generated, what correctly changes for a startup, concretely changes for a startup tomorrow if your view loses and the Copyright Office's view wins?
Yeah, and that's a great, excuse me, a great question. And I think to start out with, might be useful to use a computer program before vibe coding, that the 1976 Copyright Act, Congress sort of clearly has accepted computer programs as literary works and therefore copyrightable. And the courts later sort of dissected what are the protectable elements of a computer program, and they have provided this helpful terminology that copyright will protect the literal elements, meaning the lines of code, as well as non-literal elements such as the overall architecture of the program, different functions, and how they're organized, as well as the audio-visual outputs, et cetera, whatever. Now, the reason why we're having this webinar today is that AI has changed the method of creating those computer programs, and it's called vibe coding, which is attributed to Andre Karpathy, who just joined Anthropic this week. Uh, it's the notion that you can just use English language to have your AI agent write the lines of code. So the difference now is if you rely entirely upon the AI agent, 100% of the lines of code, the literal elements of the literary work, the computer program, would not have been written by the computer programmer. And under the Copyright Office's various guidance and its authorship report related to its AI studies, there's a serious question whether if the Copyright Office's position is accepted by the courts, there's a serious question whether the lines of code could be copyrightable, and I sort of reading or interpreting the Copyright Office's position, believe that it might not be. And then the next question becomes, well, are any of the non-literal elements that have been generated through this process of vibe coding protectable or not? So to go back to your question, I think the key difference now is when a person who vibe codes a program can no longer assume it's going to receive copyright protection because of the Copyright Office's position that an output from an AI generator that was created by prompts alone is not a work of authorship. That's a statement that the Copyright Office has made in its 2025 report on authorship. And if we take that sort of at its face value, then this vibe coding would not qualify. Now, we're going to get into this discussion today. I think there's a different approach that still can preserve a way for vibe coders to produce works of authorship. But the big difference now is I think a person engaging in vibe coding cannot assume it's going to be automatically a computer program that falls within the scope of copyright protection.
So, yeah, I mean, that frankly segues perfectly into the next question that I had, which is so your paper focuses on, as you I think absolutely correctly referred to, as selection and arrangement, right? So this idea, for folks that may not be familiar, this idea that if you generate, for instance, a bunch of AI images, right? You obviously can't copyright those AI generated images, but if you say print them out or dump them into Photoshop and make a collage out of them, or perhaps you use them as, I don't know, textures in, say, Blender to build a 3D world that you're building. Those finished arrangements could be copyrighted, right? Even while the source imagery, the source AI generated images could not be, right? So Jensen Huang, the CEO of NVIDIA, he's argued that natural language, human language, is effectively the newest programming language. As Mark Andreessen has said, it's basically the highest level in the abstraction layer stack, from assembly language at the bottom to, well, human language at the top. And that AI is now basically today's compiler, right? So no one has historically questioned, for instance, copyright for somebody writing code in C++ or Python, which then uses a compiler to produce the machine readable assembly code, right? So why shouldn't English and AI be treated the same way, with the prompt author as the source code and then AI being the compiler? Otherwise, it just seems like we're kind of arbitrarily declaring, hey, non-human spoken language can be source code and therefore copyrightable, but human spoken language cannot be and is not.
Yeah, I mean that's a great way to put it, and I think it does almost offer this conundrum that we're facing right now is that we've turned sort of AI has turned English language into its own computer language that speaks to AI, right? And so we're using our natural language to program via AI. Now, so I agree to a large extent of your sort of suggestion that the vibe coding can effectuate a selection and arrangement. I would even say to an individual image, and here's where I depart from the Copyright Office's approach in some of its earlier rejections of visual images created through prompt engineering. I think that prompts can effectuate a selection and arrangement of elements in a single image. Now, it doesn't guarantee simply writing one prompt doesn't guarantee that you've done a minimal level of creative selection and arrangement.
Sure.
But the more that you engage with the iterations, so to speak, I think it is quite possible. And it's certainly, to me, the computer programming through vibe coding is probably even an easier case to identify that this person has engaged in selection and arrangement through the process of vibe coding. Because I think like, and you would know this better than I do. Writing an app isn't as simple as just saying like, write me an app, and then it's like presto, it's
Thank
done,
you
and
for saying this. Yes.
it's like presto, it's done, and it's
Right.
foolproof, and it's exactly what you wanted. I suspect it's going to require a lot of tweaking
Oh
by
yeah.
the vibe coder, et cetera. The part that I guess I would hesitate to embrace fully the hypothesis that you threw out is I think the difference with AI and especially agentic AI, and let's say digital audio workstations and writing music through a software program. I think what is different, at least in some uses of agentic AI, is that there may be a serious question whether the human vibe coder, so to speak, has actually exercised the so-called creative powers of their mind.
Mhm.
One of the Supreme Court's descriptions of what they want for authorship, like the fruits of intellectual labor. There is at least a question or a concern that for some outputs, the human has done basically nothing, like next to nothing, right? And it's like the input by the human is insignificant or de minimis,
Yep.
and yet they're claiming to be the owner of the copyright for the work. Now, one counter argument to this concern would be, well, we seem to have accepted photography
Mm.
with like a lot of the decision making now is through the camera, like the
Yep.
software in the
That's a
camera.
great point.
And like AI is now in the software and
Mhm.
cameras
Mhm.
to get like the focus like razor sharp, right?
That's a great
And
point.
we have no problems in saying as long as you just like press the button, you've made the selection and
Mhm.
arrangement of
Mhm.
what the composition is. I think what is we've sort of accepted that the courts have accepted that as being copyrightable, even though facts are not copyrightable. So you're taking pictures of elements in the world. You're not going to be able to have a thick sort of copyright protection. But the pressing of the button is enough to like be an author, right? In that context. So I think there is analogy that does provide at least a counter argument to this notion that vibe coding at some point becomes too like trivial, the amount of human input. But I do think the court, this especially the Supreme Court, in thinking about authorship, provides us some principles, some guidance on what authorship is entailing. And the selection and arrangement is definitely one that they found in the photography case, the Burrow-Giles case, right? That was a big question. Is the simple act of taking a photograph an act of authorship? And the argument that then was, it's just like a machine, has captured the world. And this, the Supreme Court, I think, is in its infinite wisdom. I mean, it's like a landmark decision said, no, we think that we interpret author in the copyright clause as being, more flexible. And it said, what did Sarani do? Well, he selected and arranged what, the Oscar Wilde and the Pose, et cetera, whatever. So to go back to your suggestion and the question, yes, selection arrangement I think is incredibly useful in thinking about when is the vibe coder an author? When does the output become an act of authorship for the vibe coder as opposed to something that seems, offloading all the work, the creative work to the AI agent?
So that's yeah. So well, in that case, before going on to the third question, that just for context, I think it's worth mentioning something you just reminded me. Yeah, so for context, whatever you see in social media, you can't really whip up a meaningful app in like a weekend or even, let alone one night. The things that I build take anywhere from, say, 30 to 40 hours for my first iOS app to 80 plus for my first web app. And granted, it's because I was getting started, but the point is, this is not a trivial thing by any means. You've got to have still a pretty robust understanding for how web and iOS frameworks work. You've got to understand technology stacks generally. You can't just do it. But to the point that you just made, and the analogy with respect to taking a photo, it's an interesting one which we could unpack some other time. It's a deep rabbit hole of a discussion, frankly. But in the limit, like I don't know if it's, whether you believe it's 5 years, 10 years, 3 years, 20 years, whatever, at some point you're right. It will be equally trivial, like we've seen in Star Trek forever, where you just say, hey, computer, build me a thing that does something that I need. It will be trivial. There will indeed not be any actual authorship in this traditional sense, right? And so I think that's the overarching question, which is precisely what my next question is for you. um, as you say in the paper, the Copyright Office literally actually says that prompts alone don't satisfy the traditional elements of authorship, right? So, like, isn't that the point? That, is selection and arrangement sort of a tactical choice then to meet the office where it is now? Or do you think that this kind of traditional authorship doctrine is perhaps indeed the right ceiling, that maybe purely vibe coded apps shouldn't get copyright protection? But you see, it's kind of a recursive question because you kind of preempted that too, namely pushing the shutter, authorship, asking a computer to build a thing. Is that authorship? I don't know. How does this play out?
Yeah, I mean that's a great question. I think, and I'm already on record on this with my writings. I think the notion of there is a requirement of traditional elements of authorship is completely wrong. That's not a term that any federal court has ever
Mm,
used. The origin of this, and I discussed this in my earlier law review article, the origin of that term is from the Register of Copyrights Kamenstein's annual report in 1965, and the statement that made in that report is rather tentative uh, in referring to it may involve like traditional elements of authorship, but it also includes selection and arrangement in that discussion, which is like exactly like I think that the key point from the Feist opinion by the Supreme Court. So I think the notion of anything traditional, it goes against what we just talked about with Burrow Giles and the Supreme Court interpreting authorship in the Copyright Clause and said, no, we don't think authors means book authors, which is actually the traditional notion of authors, dating back to the Statute of Anne,
mm,
protecting
mhm,
books,
mhm,
creators, authors of books. So the Supreme Court in 1884 says, we think authors is far more flexible and provides this very, I think, expansive definition of author, he to whom anything owes its origin, right? Creator,
mm,
maker, et cetera, or whatever. So I think the notion of traditional is the wrong, is like the wrong sort of approach. And we need to stick with the Supreme Court's approach in especially Feist is the most recent, I think,
mm,
decision on authorship related to authorship. And then as far as sort of what um, should be the approach that the courts adopt in reviewing the Copyright Office's positions. Uh, I think we'll have to wait and see. There is a case in Colorado, Allen versus Perlmutter, in which the prompt engineering of a visual image is at issue. And the Copyright Office's position, I think I'm being fair in describing it this way, has been somewhat of a moving target. There's sort of a de-emphasis in that case with the traditional aspect of it, and more emphasis on this notion of control. Like there wasn't enough control by Mr. Allen in using Midjourney to produce this visual artwork that received award at the state fair. I mean, it was like an impressive artwork that he used, hundreds of prompts to generate. And what was emphasized, I think, in the briefing is some notion of lack of control
mm,
over
mhm.
what the outputs generated. And I also think that is not the right approach either, because there are a lot of works that the author does not control, the subject matter. And to go back to photography, landscape photographers, wildlife photographers have no control over nature, right? You might take, and actually it's interesting because uh, uh, Oliver Wendell Holmes Sr., uh, the father of Justice Holmes, wrote this essay describing the process of taking a picture and like serendipity
Oh,
involved
yeah.
in capturing some subject matter that you sort of the person taking the photograph had even no idea that that was being photographed. And I think wildlife is a great example where you could be shooting wildlife in the wild, so to speak, and capture something that you had no idea would even occur. Right? You're kind of like at the right place at the right time, kind of thing. There's no doubt that you're the author of that photograph, right? The fact that you don't have control over uh, even like a central element. Let's say you've captured, I don't know, bald eagle as an example, but you weren't even planning on it, right?
Mhm.
You were thinking you were going to get a picture of I don't know, the mountains, or a picture of a desert, and well, I guess bald eagles won't be in a desert, but the
But the bald
ocean.
eagle photo bombed the photo.
Yeah, the ocean. The ocean is a better example.
Yeah.
The ocean, and the bald eagle appears, and then suddenly, like this photograph that you've taken is like your, signature piece. Like you're known for it. Should you lose a copyright because you had no planning and no control over that bald eagle? Of course not, right? Like art is fluid, right? Creativity is fluid, and this person was responsible, was the maker of that photograph. And I would hope that once the courts resolve this issue, they accept what I interpret to be principles of law already established by courts. I'm not advancing anything new in my view. Like I'm just saying like, well, here's how you apply existing principles that especially the Supreme Court has articulated in its past cases related to authorship. And let's apply them in this context. And I like your suggestion about selection and arrangement as being a central question that we should be asking in the context of vibe coding.
I mean, it's a perfect parallel to the argument that, well, I guess basically what we're saying then is that photography, therefore, like generative AI, is by definition non-deterministic to a sense.
Yeah,
So
there's some fluidity
yeah, they're really
uh,
parallel things.
to
Yeah, yeah, yeah. No,
to
great.
creation, and when we don't require the author to have been in
Hmm.
control of everything.
That's fascinating. Wow. Yeah,
That to me that just seems such a sort of a straitjacket, right?
yeah, yeah, yeah.
You're like you're going to plan everything, and then you're limited, right? And that to me goes against creativity. You want to have some allowance for serendipity or spontaneous elements that you were lucky to be a part of, right, as the creator, but you're not necessarily disqualified because, oops, the bald eagle appeared, and you need to disclaim the bald eagle.
Oh, wow, amazing.
Yeah, absolutely. Well, I have another question on this, kind of picking up on the thread of how courts might resolve this. We've explored throughout this conversation the sort of spectrum of using AI to create. There's the flashcard app example that you provide in your paper, and there's the iteratively designed website. And a lot of the vibe coding lives in this messy middle. So, how are courts supposed to administer did a human make an original selection and arrangement test? Do we end up litigating prompt histories the way we, have been litigating access and substantial similarity? Yeah, do you have any workability concerns?
Well, the first caveat I would say is this will only come up, well, it would come up in two places. One, if you attempt to register it with the Copyright Office, which is saying you need to disclaim any AI generated element. So that's one context. Registration is required to sue somebody for a copyright infringement. And then that gets me to the second context. It would only come up if you're actually suing to enforce your copyright over what you believe, your work of authorship is that you created in part through AI. Uh, in terms of whether you have to show your prompt history, et cetera, or whatever, uh, yeah, that certainly is one approach that might be adopted in part to winnow out the circumstance that I was talking to Mark about, the scenario where the de minimis input by the human. So how do you show that it wasn't de minimis? Well, you might have to provide evidence of what you did. And as I said before, we only have one pending case on prompt engineered image in Allen versus Perlmutter. So the U.S. courts have not dealt with this issue. Now, if we look at China, if we look at China, which actually has the most cases related to AI generated works and authorship, some of the cases there do require proof of what you did, what your prompts were, et cetera. And then there's also a couple cases from the EU take a similar approach. To the extent that it's saying there was no evidence that what you did to make a selection arrangement or otherwise satisfy their requirements of authorship. So unfortunately, I think to some extent, there is some precedent outside the United States for having a sort of a evidentiary requirement proving I did this. Now, you mentioned workability at the tail end of your question. Yeah, I mean, it does seem like um, you know, people using AI need to be aware of this then, right? They need to be establishing a record to make sure they preserve their prompts. And one of the works that was successfully registered in the Copyright Office, they took a video of their prompt engineering and tweaking and editing of it's a what is it a single slice of American cheese. I think that's the name of the visual image. They took a video of what they did, and I don't know if like all creators out there are going to be have the wherewithal to think I need to create a video of what I'm doing. I don't know, Mark, you're going to be taking a video of yourself and your vibe coding or whatever. That it may come to that, but that got approved as far as like it did something beyond what the Copyright Office has otherwise rejected for other AI image generated works. Now, the workability of that, well, it seems like it does provide, it does create, administrative burdens, evidentiary burdens for creators that they need to be aware of this. Zachary Cooper has written about this. He's another copyright professor. He's written about this, and he completely disagrees with this. I think he would characterize it as being an insane approach to have this sort of dissection of the creative process. But so far, there in other countries at least, there are some cases where it is required. So if you don't have proof, you might be out of luck, and we'll see what happens in the United States.
This is kind of funny and interesting at the same time because, first of all, I mean, I think to the point of Amanda's question and what you kind of alluded to just now, first of all, whenever you commit any code to GitHub that you wrote with Claude Code, I don't think there's any way to turn off the co-authorship label that Claude Code includes on all of your commits. It always says co-authored, your name with Claude Code. I don't think you can get rid of that, first of all. So I suppose as far as evidentiary support, you could just go through somebody's entire, GitHub history for any particular repo in question. And then second point, real quick, is I guess now this suddenly gives a lot of practical value, or at least legal value, I suppose, to the so-called building in public communities that are now so popular on X, where people are literally sharing sort of, in some cases, literal actual live stream or indeed real-time status updates of everything that they're writing and building with AI. So yeah, that's a that's a really interesting point. How you going to prove any of this? Um, so look, I know that this event is technically scheduled for a 30-minute CLE. We've already got some pretty great questions coming in. I would like to squeeze in one quick last question at the end here, please, if I may, and then we can jump to some questions, time permitting, with you, Ed. So.
Sure.
Um, so the thing I mentioned right before we started this, or at the start, so you did kind of preempt part of what I want to ask here with one of your recent LinkedIn posts. You argued that for most apps, copyright isn't really doing the protective work anyway. It's mostly trade secrets, patents, trademarks, contracts, and I like that because, yeah, self-servingly, I've sort of said the same. So I guess my question is, if that is indeed correct, and it seems like it is, then like I'm not even sure how to ask this, but like isn't the whole vibe coding copyright debate almost like a sideshow? Like it's not even directly relevant. In other words, where this is headed is sort of unknown, right? Like if you think about the next billion-dollar app, which is for sure going to, I mean, everyone's saying that we're going to have the first single, solo founder, uh, billion-dollar unicorn company that was vibe coded from scratch, right? Um, with respect to the venture market, how do they price this out 5 years hence if nobody knows who's really owning the copyright, if that's even a valid question anymore?
Yeah, I mean, things are moving so quickly that we're having this debate today, but next year things may look even more different in terms
Yeah,
of AI vibe coded programs and those programs creating their own programs. I
yeah,
mean, Dario Amodei is suggesting that, copyright's going to be, excuse me, computer programs are going to be free
yeah,
because they're
yeah,
just
yeah,
going to be all created by uh, AI agents and improved by AI agents in the future. I don't know when that future is. So yes, that's certainly a possibility, and we just need to constantly evaluate the changes to this particular sector and see if copyright is still necessary or still relevant. For my perspective, in the immediate, sort of time, I think the reason why it's important to retain some copyright is that the transition would be so stark. As my answer to Amanda's first question is 1976 Act says, after decades of study, computer programs folded into the Copyright Act as literary works. And one benefit of that we haven't discussed is you can file a DMCA notice if unauthorized copies of your computer program are being shared. And that's what Anthropic did just a couple weeks ago when that happened. So it's not, I think, uh, sort of no value or no practical use to the creator of vibe coded programs to be able to have a copyright and say, well, look, there's unauthorized copies of my program being posted on GitHub or whichever platform that it was posted to. And that I think that example shows the importance of copyright, at least in the view of the creator of the program here, Anthropic. And yes, perhaps in the maybe not too distant future, it just becomes so overwhelmed by agentic AI, just creating programs where it's just so easy and more of the vision that Amade talked about. And maybe copyright is not needed, and we should just move on. And it's like open source, everything is just free, and that kind of thing. But for the near term, for the present at least, I think we still do need copyright for computer programs, and I'm suggesting in my paper that vibe coded programs should at least get a thin copyright if there is this original selection and arrangement of elements being made in the architecture or in the audiovisual elements, the interface, what the person sees, subject to all the usual exclusions that copyright law recognizes already.
That's a fantastic place to end. Thank you so much, Ed. And to everyone who asked phenomenal questions, we're so sorry we couldn't get to them. Please join us at our next AI and the Law section event where we'll discuss this and much more. And thank you again, Ed, for being so generous.
Oh, it was my
with
pleasure.
Time and perspective.
Thank you.
Great.
Thank you, Ed. Thank you, everybody,
Thanks,
for coming.
everyone. Take care.
Bye-bye.